Thank you for joining us for Legacy and Protection, Estate Plan for One-Parent Families. I'm excited to chat with everybody this morning about estate planning. Whether you're solo parenting by choice or circumstance, we know it takes a lot and want to make sure we are able to really understand estate planning and how it works in all circumstances, but specifically when we've got that unique situation. And so today we're going to highlight some of the elements of estate planning and how, when you're going through the process of setting up a will or a trust or your powers of attorney, you might do so in a way that is really protective for your children in the event something should happen to you. So with that, I'm going to briefly introduce myself. I'm an Arizona attorney. My name is Emily Taylor. I practice in the Phoenix Valley, but I'm able to work with clients throughout the state. I grew up in the Midwest, came to Arizona to attend ASU, and then I stayed and went to U of A for law school. Since that time, I've been practicing in the planning, probate, guardianship arena. I am a member of the Special Needs Alliance, as well as the National Academy of Elder Law Attorneys, State Bar of Arizona, and all sorts of things. And I feel very fortunate to have the practice I do. We've got a great team and great to work together. We're going to talk today about this concept of estate planning. And a lot of times we hear this term and we might have preconceived notions of what that might mean. A lot of times we think about the movies we've seen, the TV shows. Sometimes we have personal experience. Perhaps you've lost a parent or other close relative and had to help administer their estate. But in general, the terminology estate planning is really trying to think about what happens in the event you are unable to act on your own behalf as a result of disability or death. And so we need to consider not only what happens to our estate, our assets, so to speak, at our death, but also between now and then, how do we put in place the right instructions, the right documents to make sure that we have structure for allowing our team that we've selected carefully to step in and help us make personal and financial decisions. When we're talking about estate planning for one-parent families, we also need to consider that if your child, whether they're an adult or a minor, is relying on you and you alone, that adds some extra things we need to start thinking about. And so a lot of times we have this idea of estate plan. It's going to include wills, trusts, powers of attorney, healthcare directives, beneficiary designations. I'm going to break down each of those things. And so that is really our estate plan, but it also is our legacy. What is our piece that we can leave behind to make sure that things go as smoothly as possible? And so people have different goals. And a lot of times this is directed based on the timeline. So if you have young children, you may be concerned that if something happens to you, they'll need a guardian. And who is best to be that guardian, and how can we set that up? Your children are also young, you might be thinking about making sure that their assets are managed in a way that perhaps they may not have the experience to manage. Of course, that doesn't mean the day they turn 18, they suddenly have the ability to manage all those pieces, but we want to structure that through young adulthood to give them the protection that they need so that they can have opportunities on how to learn and manage money their own way. We also typically want to avoid family members fighting. So sometimes we have different family members or people who might have priority under the law who may disagree about what is best for you or your children. And so by allowing you to put into place these structures, you can overcome some of that by giving priority to the people who you believe have similar philosophies and goals and believe will act and advocate on your behalf. We also want to protect our children, so the best we can, doing that through the guardianship as well as the trust for the minors, setting those different pieces up. And then we want to leave a legacy. So to the extent there are financial assets to leave behind or you're building that, we want to make sure that the memory of how you left those is in a way that these resources allowed for your family to continue their education journey or to set up early adulthood, the ability to establish a home. to pay for weddings, to pay for graduations, those types of things. And so our ability to use an estate plan, these legal documents we're going to put in place to kind of define all these different pieces really gives you a sense, I hope, of comfort and structure so that you can make sure things are moving forward appropriately. So I mentioned briefly, but want to kind of review, we've got a lot of different documents as well as decisions that really compromise a complete estate plan. A lot of the terms may tend to overlap, and so we really want to define what each of these things are, and that's part of our goal today. So with that, basically we want to make sure that we've got a will, a trust. We want to have a living will, meaning a document that's going to direct what happens at the end of life. We have other healthcare advance directives like healthcare power of attorney, mental health care power of attorney, financial powers of attorney, but we also need to be mindful of beneficiary designations and co-ownerships and other things that may supersede our estate planning documents. We're going to start a little bit talking about health, and this is important for you because if you've had the opportunity or unfortunately the requirement to go to a hospital and need to be checked in for surgery or be admitted, they're going to ask, do you have a healthcare power of attorney or a living will? Now, in that case, if you say no, sometimes the hospital will help you put one in place, but sometimes they won't. The reason they want to know this is because if you're unable to make or communicate your healthcare decisions, we want to make sure they know who to contact, who can speak on your behalf. And in essence, that's what the healthcare power of attorney is. It's your opportunity to put a team in place, whether it's individuals or professionals who can step in and make your medical decisions when you're no longer able to, either because of illness or injury, or perhaps it's just a temporary situation where you're under anesthesia and they need somebody to make a decision. So with that, the healthcare power of attorney in Arizona also allows us to make a few other decisions. Commonly, you will see in your healthcare power of attorney an opportunity to provide instructions regarding organ donation, whether or not you want to be an organ donor, and if you do, providing some guidelines to your family or decision makers about what they should do on your behalf in terms of research or transplant or the like. We also have a mental health care power of attorney in Arizona. This is somewhat unique nationally, but mental health care power of attorney is going to be for mental health care decisions, but specifically inpatient psychiatric care. And so in the case of both a healthcare and a mental health care power of attorney, our goal in structuring these and giving this authority to our, what we would call agents, allows us to hopefully avoid a situation called guardianship. So guardianship, unfortunately, is in a circumstance where either you can't or you haven't put a healthcare power of attorney in place and the court needs to get involved. And the court in those cases is going to look at medical evidence to make a determination about a person's ability to make their own decisions and then grant that authority to act to someone else. So that guardianship process tends to be stressful if it's an emergency medical situation, but it's also something that takes time and cost. And so if we can avoid it by putting the powers of attorney, this is going to be important. You'll also see on here living will. Living wills are our opportunity to be able to put into place some of our outline related to what are the decisions we want our agent to make. So giving direction about life prolonging procedures. We think commonly of ventilators and feeding tubes and the like. It's going to allow us to give direction on pain management, hospice care. You also, in some circumstances, might find that a living will allows you to put some direction in place should you have advanced Alzheimer's or dementia. So those living wills are really going to be helpful. And occasionally in situations where there's a contest about what you would want, that's going to be evidence to give the court some direction or the hospital some direction on what you want. But largely it's just to help your healthcare power of attorney make a decision. And then of course we have a lot of other acronyms. HIPAA, most of you are familiar with. That's going to be your health information and protection. Medical providers are subject to HIPAA and required to be very restrictive with sharing your medical information. However, we want to make sure that the right people can get that information at the time. We also have DNRs and POLST forms. A DNR is a do not resuscitate. A POLST is a physician's order for life-sustaining treatment. Both of these are documents that are instructive to doctors and hospitals. We need them to be posted and well circulated so that the pieces can be conveyed. But in both of these documents, your primary care or an attending physician should review it with you and sign off on it so that you're clear about what that means. In the context of you as the adult, as the solo parent, these are all very important to make sure that if something happens to you, you've got the right people in place. It's also very important that as your children near adulthood, if they have capacity to review and understand these documents, the day they turn 18, they're an adult. And that limits your ability to continue to work with them or provide for them in the medical setting. And so you're no longer able to make and drag them to medical appointments. So sometimes we think after our child has turned 18, if they're considered an adult, then they should also review and sign these documents. So a lot of times we're putting these in place as they head out, perhaps for college or to start their first job, to make sure that the right people continue to have that power to make decisions. If you're solo parenting because the other parent perhaps is absent or wasn't appropriate to parent, it's really important too that your child sets forth their intentions about who can make these decisions, because under the law, in the event a guardianship is necessary, then certain people are entitled to notice. And that's both of the parents unless parental rights have been severed. And so we want to make sure we've got the pieces in place so that if there's a reason to not involve the other parent, we want to make sure that that's clear. So just something to think about with your young adult children and making sure things are put in place. We also want to do the same with financial decisions. So for you, you need a financial power of attorney. Oftentimes it's called a durable general or a general power of attorney. This is going to be instruction and nomination of agents to make financial decisions for you while you're alive. And either that might be a document that's effective immediately or only upon incapacity, meaning that a doctor would need to say that you're no longer able to make your financial decisions. Now, in this case, we're also talking about avoiding a conservatorship. So in Arizona, guardianship and conservatorship both fall under our probate court, but they're both processes where when a person's not able to make these decisions and they haven't done their power of attorney documents, the court needs to get involved. So it's very important that we have this in place. And just like I mentioned with the healthcare, we also want to consider putting this in place or helping our adult child put this in place after they've turned 18, so as to not have a lapse of priority there. The other thing to really be mindful of is that when we are talking about powers of attorney or assets, both in the context of decision making, but also when we're thinking about access while you're perhaps alive but unable to make decisions, or after you pass away, we always need to be mindful of co-ownership and signatories on accounts. That's because we want to be clear about who has priority and access to our assets. So I always encourage you to double check with your financial institutions who are, in fact, the owners of your accounts. Sometimes you may forget, as I did, that my mom became a co-owner on my original bank account that I set up when I was 18. And if I continue to use that bank account from time to time, I may suddenly remember that she has access. Now that's okay for me, but in your case, you probably want to be really clear about who has authority and access over accounts. And you do want to be careful. Usually you never want to add an adult child to your account as a co-owner, because then that can expose your asset to their liability as well. So using powers of attorney and the like are a much more consistent and safe way to make sure that somebody has the authority to sign and act on your behalf, but their liability doesn't expose your assets. We also have parental powers of attorney. So as a solo parent, it may feel like you're not able to take many solo vacations or take off without your kids in tow. However, in some circumstances, if you're in the armed forces or if you have a job that requires travel a lot, perhaps you're in the airline industry, or perhaps you do have a team that's able to support you and support the kids while you're able to take a break or a vacation. Sometimes a parental power of attorney is an important document that you can put in place. In Arizona, these are effective for 6 months or less, and they allow you to add another adult to make decisions for your child. Now we kind of transition to the documents or estate planning elements that are put into place after you've passed away. A last will and testament is a common document. You may be familiar with these. A lot of times they come up in movies and murder mysteries. Last wills do a couple really important things. First of all, they're going to help us nominate what we call in Arizona a personal representative. A lot of times we're familiar with the term executor, but in this case, we're looking at a personal representative. Who do you entrust to, if you should pass away, collect your assets, handle the obligations that they're required to follow? So collecting your assets, paying bills, taking care of taxes, and then making sure that your estate gets distributed according to your wishes. Your wishes are also part of what's going to be incorporated in your last will and testament. And that might mean you want to say that things go to your children, for example. And you may want to set that up so that the way they inherit their asset does not involve their other parents if they're still alive. And you may want to make sure that they perhaps have a responsible adult or professional to manage those assets until they reach certain levels of maturity. Of course, 18 is legally adulthood, but for many young adults, it takes kind of some trial and error before we learn lessons about how to invest and manage money. And so we want to make sure they have the opportunity to do that, but not suddenly with the entirety of your estate on their 18th birthday. So in a last will and testament, you may say that your children would inherit and they're going to inherit in trust. This trust is going to be set up with a trustee in place. That might be a sibling or a parent of yours or a professional if that makes the most sense. And then you want to be clear about what those assets can be used for, as well as sort of ages or intervals in which the beneficiary has more direct access or control over those assets. Last wills and testaments also allow us to nominate a guardian. So if your child is under the age of 18, or if you have an incapacitated adult child and you should pass away, they may need a guardian. Now, I say may because if the other parent is still alive and their parental rights have not been severed, then they're automatically remaining still the parent. And so despite what you might have in place of custody and the like, or any other sort of entry during the divorce, they still retain their rights as parents and guardianship may not be necessary. Now, occasionally, obviously, some people might adopt on their own, or perhaps you've lost the other parent. So if you are the only parent in place, we really want to make sure that that guardianship's in place so that there's an easy transition to make sure that the right people can step in and make education, living arrangement, and other decisions to protect your child. All of these are really great things to have in place. So wills can be very, very important. Now, one thing I caution relying on a last will and testament is that in order for the wishes that we've put in place to be effective, the will has to go through a probate process. So probate in the traditional term is the giving the will to the court for the court to approve it, notifying people who are allowed to be or required to be notified, and then deciding in the case where there's not a will who the heirs are, but if there is a will, making sure that that personal representative has the authority to act. And then the court goes ahead and supervises the administration of the estate. Under probate laws, that does require certain notice to creditors and other steps that the personal representative is required to take, and therefore can sometimes slow down the administration timeline. It also opens up an opportunity because if probate needs to be undertaken, whether you have a will or not, that last will and testament, despite the fact it may say that certain people you don't want to be involved, this may require that they be given notice because they are still the surviving parent of a minor child. And so it may involve and share information and not provide you the level of privacy you want. So while last wills and testaments are really great to put all those pieces in place, there is the default laws that are going to require, in some circumstances, the involvement of either the other parent or their family members in a way that you may not want or have want them to have any information or involvement. So sometimes we want to avoid probate. Commonly, we're thinking about doing that in Arizona by using a living trust. So a trust, much like a last will and testament, is going to be a legal document full of big words and legalese, but our intentions overlap quite a bit. It's going to allow us to put somebody in charge or nominate somebody to be in charge. In this case, rather than a personal representative, we're going to call them a trustee. It's also going to direct the administration of trust assets during life, incapacity, and death. So you can see that that time horizon is much longer with a trust. And if the trust is properly funded, it's going to allow the assets to pass outside of probate, meaning that the court won't get involved. That means that we don't have to give certain people notification. The terms of the trust are going to control. Now, when I say properly funded, this may be the most important part of trust planning, is that you need to make sure that the asset ownership and beneficiary designations are structured such that at the time of your death or while you're alive, your assets are already owned by the trust or are going to flow into the trust through a non-probate transfer. Trust documents themselves don't do the magic we need them to do. Not only do you need the document, you also need to understand how it works, and then you need to go back through your assets, make sure that those are structured properly to flow through the trust, and then you also need to be mindful that during the rest of your life, when you open new bank accounts, when you buy new houses, when you inherit assets, that your assets are structured accordingly. So a trust is a working and a living tool that allows us to do a lot of very important things and save or solve for a lot of potential headaches, but it is something that you always need to be mindful of and working with. And so trusts are really great tools, but they're not magic. In this case, we also, a lot of times when we have young children, perhaps we might have a child who has limited capacity to advocate on their own behalf. A letter of intent is a really important aspect of an estate plan. And what that is a statement of your wishes or intentions related to kind of the non-legal management of the assets. So for example, if you have a case where there is a beneficiary who is young, you may want to spell out what your goals are for their education, for their healthcare, for how you hope that they are raised in terms of financial education and other things. So letter of intent is a very important tool that you might want to put in place. Typically, this is going to fall outside of the technical legal documents and instead be a separate writing that is referenced by your legal documents. So who's all involved when we're talking about an estate plan? As you can hear, there's a lot of different players. And so these teams, we hope, are in fact dynamic, meaning they all work together. They create a system of check and balances that allow for your children, whether they're minors or adults, to be set up and structured in the right way. So we have healthcare powers of attorney. These are going to be great for who can make your healthcare decisions. We have financial decision makers. This may be a very different group of people or professionals. The ability to be an advocate in the hospital setting does not mean that they're going to be great at balancing a checkbook, filing tax returns, and working on a lot of different documents. We also need to consider who our beneficiaries are. So again, structuring things for our children, minors, adults, family members, other people. We also want to think about how those beneficiaries are going to receive these assets, and that means being intentional about the structure that they will inherit. Guardian nominees is obviously very important. We want to make sure that that guardianship piece is in stone and is clear about who has priority under the law, so that in the event there are any disagreements or anybody kind of comes out of the woodwork, that they've got the structure they need. And then contingencies. We always need to have backup plans. So in each of these areas, we want to make sure that we've got a good backup plan there. Now I'm going to quickly kind of go through 5 estate planning myths that hopefully, if you've followed along so far, you'll be able to clearly point out what is not true. But myth number 1 is that estate planning is only necessary at certain life intervals. And that's not true. Anytime we're talking about any of these pieces, whether it's for you or your children, it's really important that if you're an adult, if you have any assets, but especially if you have any children, that you've documented some of your intentions. We can easily avoid guardianship and conservatorship by having powers of attorney. We can be mindful about our estate administration when we think about beneficiary designations, co-ownership, and it's pretty straightforward to put a will or a trust in place, but it's not necessary at a certain time. If you're an adult, you need some elements of these, and you should work with an attorney who can help you figure out what the right path for estate planning and asset management after your death is. So we don't want to wait until we're ready to retire. We don't want to wait until we're wealthy. And we don't want to wait until right before we die, because unless you have a crystal ball that works better than mine, we don't know when that's going to be. Myth number 2 is that if you have a trust document, you can't go to probate. I think I said it loud and clear, but I'll say it once more, you can have a trust document in place, but your assets, if they don't have the appropriate ownership, titling, or beneficiary designations, can still require a probate to be opened. So you really need to understand how to properly fund your trust, how to make sure your assets are structured to flow through the documents that you intend so we can stay out of court. Myth number 3 is that you've signed your estate plan, you've funded your trust, and now you're ready to go. Hopefully that's not the case, but we also want to make sure that we're sharing our planning. So it's important that we engage our financial advisors, that we work with our friends and family who we've nominated in the documents to know where the documents are, where our assets are, that we communicate these things. And as our children get older, I think it's important to the level that's appropriate that we share with them what terms you have in place. That can help your estate plan be much more easy to effectuate when the time comes. Myth number 4 is I have a family member who cannot take care of their own finances, so I'm leaving it to their sibling. They'll take care of them. So in some instances, perhaps one of your children or other beneficiaries has or is receiving Medicaid benefits or Social Security benefits, and your fear that if they inherit from you, they're going to lose their benefits, in part is founded in truth, but there are many legal ways that we can structure that to make sure that the assets that you want them to have are structured in such a way that it wouldn't disrupt their social benefits, meaning their SSI or Altex or DDD in Arizona. Sometimes we have children who are just not great with money or make bad decisions. What I encourage you to consider is that there are legal ways to structure this, and we don't necessarily want to just avoid naming them in the documents and instead hoping or thinking that another person will take care of them. Because the reality is that if we rely on that other person to make those decisions, they too may pass away, and their estate may say those assets go in an entirely different direction, and now that person's left without anything. So working with an attorney can help you really prepare and plan for all of those types of beneficiaries in a way that protects them and their interests. And last but not least, myth number 5, I don't have the time or money to set up an estate plan now, but I'll take care of it soon. I find many clients in here in their 70s, 80s, 90s saying, I think, I've been thinking about this for decades and now I want to put something in place. The reality is you can start small. You can have your healthcare directives, which are available for free through the Arizona Attorney General, in place. You can put together a simple will if assets are tight, but you want to make sure the decisions are appropriate. A will is a great place to start. And a trust may be an investment that's worthy of your time, attention, and money. And so working with an attorney who might be able to set up an estate plan, a payment plan for your estate plan, can make that cost reasonable for you. And then it allows you to really keep it up to plate. So the important thing is if you're watching this, you've already started down the path. Hopefully this has been helpful to learn. If you're watching this, I anticipate you're also doing the difficult job of being a solo parent. And again, whether that's by choice or circumstance, it's really important that you make some extra steps or provide some extra considerations about how your disability or death might impact your heirs, and making sure that we understand what we can put in place for them. So with that, I'll just skip the questions, but say thank you. I appreciate you spending the time listening to me talk about these things. Of course, if you're here in Arizona, we'd be happy to work with you. You're welcome to set up a consultation through our website or call our office. If you're in another state, I encourage you to look and find an attorney that you feel comfortable talking to. And if you have any questions, please feel free to reach out to us. But I appreciate your time today, and I hope you enjoyed today's content.